I expect everyone's heard of the post office scandal. Between 1999 and 2015, the Post Office Limited brought private prosecutions against 736 sub-postmasters for theft and false accounting on the basis of discrepancies in their accounts revealed by a defective computer system which it knew was inclined to return false positives. Although this meant that some of those it prosecuted were likely to be innocent, the Post Office Limited kept this information to itself. Eventually the scandal broke, and since April of this year, no less than 72 of the convictions have been overturned by the Court of Appeal, and a number more are in the pipeline, so the total looks like rising. Not sharing information like this is a serious breach of the obligation of every prosecutor to act fairly. And the Post Office appears to have disregarded this obligation to protect its own commercial interests. Alas, this is not the only case I know of where private prosecutions, or threats to bring them, are used oppressively. Train operating companies commonly outsource their revenue protection work, that means chasing passengers for fares that they should have paid, to private companies that specialise in this kind of work. And sometimes these enforcement companies use threats to prosecute passengers for fraud offences oppressively. In one case known to me, a student paid £11.50 for a ticket for a through journey, which she lost when boarding or leaving the inevitable replacement bus, by which her through journey was interrupted. Though she could prove she'd bought the ticket because she'd paid for it online and produced proof that she had done so, the enforcement company threatened to prosecute her for the criminal offence under the Railway Regulation Act 1889 of travelling, I quote, with intent to avoid payment. Then, having sent her a series of increasingly threatening letters, they said they'd let her off if she would pay them £103.90 administrative expenses. As their administration had consisted of not reading her letters and sending her a crescendo of threatening letters, all in standard form, this claim for administrative expenses was surely quite exorbitant. To tell you yet another case along this line. Recently, this small organisation set up in business in the north of England, like a mini RSPCA, prosecuting people for alleged animal welfare offences. In one of these cases, where they eventually withdrew the case, they tried to persuade the Crown Court to award them their costs out of public funds, which surprisingly private prosecutors can claim even in cases which have failed, which they've dropped. The judge was so outraged at their conduct that at the conclusion of the judgment he said this: bullying and intimidatory conduct towards a suspect and the defendant targeted for prosecution in this company demonstrated complete disregard for the integrity of the criminal justice system. And thinking that, the judge sent the papers to the Attorney General, the police, the Charities Commission and the Solicitors Regulation Authority. The aim of criminal proceedings is to punish people with fines, imprisonment, public disgrace and a criminal record which will potentially follow the convicted person for the rest of their lives forever. For this reason, criminal proceedings are normally brought by special prosecuting agencies, the Crown Prosecution Service, the Serious Fraud Office, and some other state agencies like the Health and Safety Executive, all of whom can be trusted to act properly and not to bend or break the rules to boost their profits, because they're not in the business of making profits. So how come the post office and other organizations in these unhappy stories were able to use the criminal courts to further their commercial purposes? The explanation lies in the history of English law and criminal procedure in this country. Most other legal jurisdictions, like Scotland, for example, had public prosecutors from a very early date, and when they had them, like Scotland, were inclined to give them a monopoly over the use of criminal proceedings. But England and Wales took a very long time to follow in this lead. And in this country, we have a long history of relying on private enterprise and private citizens to bring the criminal law to bear on wrongdoers. At one time, there were no professional police forces, as well as no public prosecutors, and the state relied on private citizens to catch the criminals, as well as prosecute them. And because it's a tiresome job to catch a criminal, it had a series of incentives, offering public rewards to those who informed the authorities and brought criminals to justice. And in the 18th century, this led to terrible scandals in which dishonest people set up in business accusing innocent persons in order to claim rewards. The situation improved when police forces were created in the 19th century, and after this point it was the police who mainly caught criminals, and when they caught a criminal, the police would usually prosecute them too. But there were problems in the way the police treated suspects and in the way the police handled prosecutions. The police are good at catching criminals, but a different set of skills and ethical values are required to bring prosecutions fairly. After a series of scandals in the 1970s, the government of the day caused to be created the Royal Commission on Criminal Procedure, otherwise known as the Phillips Commission, and in 1981 it produced a famous report which recommended two main things. The first was that police powers should be codified and properly regulated by Act of Parliament. This was carried out in the Police and Criminal Evidence Act 1984, a piece of legislation which is generally regarded as extremely beneficial. Secondly, they recommended that the power of prosecution be taken away from the police and given to a new public service, the Crown Prosecution Service. And this was created by the Prosecution of Offences Act 1985. So for the first time, England and Wales had its own prosecution service. And this was followed in 1987 by the Serious Fraud Office to prosecute for cases of serious fraud. The Phillips Commission thought that with a Crown Prosecution Service set up to prosecute according to ethical principles, there was no need for private prosecutions anymore, and it recommended that they be severely curtailed. But the Conservative government of the day, with Mrs. Thatcher in charge, favoured private enterprise in criminal justice as well as everything else, and it disagreed with the Phillips Commission recommendation, and instead, in the Prosecution of Offences Act, it included Section 6, which expressly retains the right of any person to bring a private prosecution, subject to the power of the Director of Public Prosecution to take it over and either to run it or to kill it if he or she thinks that's in the public interest and gets to hear about it. In recent years, private prosecutions have grown and have flourished, and two things have helped to lead to this. One is privatisation. Organisations like the Post Office and British Rail, which were formerly organs of the state, have been turned into commercial enterprises, or enterprises which at least are supposed to operate commercially. In the days of the Phillips Report, these were agencies of the state and could be left to do their own prosecutions, but now they're commercial undertakings. Like all commercial undertakings, they seek to make money if they can, and it's they who have inherited the power to prosecute for offences in their area. The second thing that's caused private prosecutions to grow and flourish are cuts to public funding, reductions to the funding of the Crown Prosecution Service, which of course reduce its ability to take cases, particularly ones which are complicated and likely to be expensive. But I hope you will agree with me from what I've said that private prosecutions are a problem and that something should be done about them. Isn't the simple answer simply to abolish them and give the monopoly of prosecutions to the Crown Prosecution Service and the Serious Fraud Office, much as is the position in Scotland? However, politics favour privatisation still, and private prosecutions do sometimes serve a useful purpose, even when they're brought by commercial undertakings. To contrast with some of the cases I mentioned earlier, there's the DAS prosecution. DAS, D-A-S, is a big insurance company whose directors over a number of years systematically made profits on the side at the company's expense. When DAS discovered this, they were outraged. They took the case to the police, which didn't want to know. They took the case to the Crown Prosecution Service, they didn't want to know, and they took the case to the Serious Fraud Office, which didn't want to know. So they started a private prosecution, which ended with one of the directors getting 7 years imprisonment, another 4 years and 3 months, and another 3 years and 9 months, and then confiscation and compensation proceedings for sums totalling millions. In this case, surely, justice was done by a private prosecution. The classic argument for private prosecutions is they're a safeguard against inertia and corruption in the public authorities. Give the brave little man or the brave little woman a weapon against anonymous officialdom. But as we've seen, these days, private prosecutions are often brought by companies, not flesh and blood human beings, and by the financially strong against the financially weak. When the Phillips Commission recommended the curtailment of private prosecutions, it said the right should be retained for someone who asks the public authorities, who asks the Crown Prosecution Service to prosecute, and they refuse, to go to court. And if the court thinks the prosecution should go ahead, then the private prosecution should be allowed. Surely that is the sensible solution to adopt. It's now 40 years ago that the Phillips Commission made this very sensible recommendation, and surely it's high time to enact it now.
Dear world, yours, Cambridge.